So I will present us. Louis Amato-Gossi, my partner in Toronto, is the co-leader of the Transportation and Logistics Group. And I'm Marie-Hélène Tremblay, a partner in the Montreal office, as you can see from my accent. And I do specialize in tax dispute and commodity tax. We're very happy to have you with us today. The presentation that we have today is a presentation where everyone has been muted in order to make sure that the sound will be good during the presentation. If you do have any question, please write them down in the chat and we'll make sure to answer your question through the presentation. This presentation will be shared to you after it also. And if you have any additional questions or want to discuss with both Louis and I after this meeting, please reach out to us at any time, either by email or by phone. We're always available and happy to discuss with you.
Thanks very much, Marie-Hélène. Good afternoon, everybody. Good morning if you're joining from elsewhere. So there's this decidedly quirky development emerging on the Canadian side of the border, which is targeted solely at cross-border motor carriers who employ non-Canadian drivers and owner-operators. And that's what we're going to be focusing on today. We think it's of it's timely and it's of great interest to all of you who are active in the transport and logistics industry, particularly if your operations include cross-border activities, or if you're an advisor to those industries. In a nutshell, Canada Revenue Agency, our federal tax authority, has recently started auditing U.S. motor carriers for failure to withhold Canadian taxes from the remuneration paid to their drivers under Regulations 102 and 105 of our Income Tax Act. That's what we're going to be focusing on today. And buckle up because it's a really interesting story.
So it all starts with the potential application of Regulation 102 and Regulation 105. So I know that lots of you right now probably don't know anything or very little about Regulation 102, 105. So in order to be able to explain to you exactly what's going on with this new incentive and initiatives from this area, we'll get a little bit more into the details of what are exactly Regulation 102 and 105. So as it says, it's coming out of the regulation regarding the Income Tax Act. And CRA is always looking for new audit initiatives. It is not uncommon to see a new initiative, but this one seems to be a very important one. They targeted other industries and they are now going into the transportation industry. So Regulation 102 is a regulation that applies to an employee who's a non-resident of Canada but renders some of his services in Canada. And for that, normally speaking, an employer, even if the employer also is a non-resident, is supposed to make withholdings on the salary that is paid to the employee. And this applies to basically any employer-employee situation. This applies even if the employee normally performs all of his duties from, let's say, a place of business that is situated in the United States, but only goes to Canada for a day or two during the year. What the regulation says is that the employer needs to report to work at an establishment of the employer in a province in Canada beyond the limits of any province or outside of Canada. So what does it mean exactly? Well, report to works means everything, meaning anytime an employer works. And they say to an establishment of the employer. Well, the establishment of the employer, as you can see, it can be an establishment that is situated in Canada, but it can be an establishment that is situated outside of Canada. So one of our thoughts, Louis and I, when we started working on this initiative was, well, is there something we can do when an employee is not reporting to an establishment? For example, an employee who works from his home all the time, or in your case, a driver who is already always on the road, never at the establishment of the employer. Well, the answer to that, unfortunately, is no, because if an employee never reports to work to an establishment of the employer, he is deemed reporting to the establishment who pays his remuneration on a yearly basis. So for sure, it applies to everyone. And the withholdings that are targeted by Regulation 102 are the normal withholdings that we do in Canada for on the income that is paid to an employee. So we have federal withholdings that are being performed, and we also have provincial withholdings. So that these are the normal rates that we will apply for an employee who works in Canada. So for example, if we take an employee who works out of Quebec, we will be doing withholding tax on a federal level, as well as the Quebec withholding taxes. The rates can be quite high. We also have Regulation 105. It's a little surprise, this one. Why? Because it applies to basically anyone who receives a remuneration which is not attracted by Regulation 102. So it says that every person, and you'll see every person represent a lot of different person, I'll go through the list, pays to a non-resident a fee, a commission, or another amount for services rendered in Canada, then we have to make a withholding of 15%. So what does it mean? First of all, who's a non-resident person? Everyone, a self-employed individual. So if you have a subcontractor, for example, it applies to corporation, to participants in a joint venture, to members of a partnership. A person is basically everyone. The payment needs to be a fee or commission or another amount. Again, it's largely interpreted by the Canada Revenue Agency to basically applies to any payment that we receive in exchange of a service. And the term service performed in Canada or service rendered in Canada is also very large. So again, if you go to Canada for just a day or two and you work out of Canada and render services out of Canada, this will automatically target Regulation 102. The difference is because you're not an employee, when you're under Regulation 105, you don't have the normal and general withholdings that we apply for employees in Canada. There's a general withholding of 15% that will be applied, which still can represent a very large amount of money. And obviously, it won't come as a surprise. You cannot apply both Regulation 102 and Regulation 105 at the same time. When Regulation 102 applies, automatically Regulation 105 won't be applied to a situation. It's just a way to avoid any double taxation. So that's the general rule out of that.
So you might think that surely none of this should apply to cross-border motor carriers. Well, historically, you would probably be correct. But based on Canada Revenue Agency's current interpretation of the Income Tax Act, as well as these two regulations, and specifically with regard to the Canada-US tax treaty, under their current interpretation, yep, it can and does, in their view, apply to drivers, truck drivers, whether they are employee drivers or independent contractors. We'll refer to them as owner-operators from this point on, who cross the border and perform a portion of their services on Canadian soil. So have a look at this. Mary-Ellen, maybe you can just walk us through what we're looking at here.
Yeah, for sure. Sorry, because honestly, on a slide, it's never easy to see these type of letters, but I hope you have a big screen, and if not, print this slide. I think it's quite relevant. So this is the general audit letter, the first letter that we will receive when one of our transportation companies is audited by the CRA under Regulation 102 and 105. And when I say it's a typical letter, I know other clients who were audited by the tax authorities, and they all received the exact same audit letter. So that's basically the first correspondence that a taxpayer will receive when an audit is being instigated by the CRA. What's striking us in this case, because I mean it's a normal letter, what's mostly important is in the middle of the first page, everything that is being requested by the taxpayer. So obviously they want the list of all of the non-resident employees as well as Os, subcontractors, who provided at any time during the period which is audited, which is mostly 2 or 3 years period, normally speaking, and who provided services in Canada with their detailed address and their business number if they had any in Canada, a breakdown of all of the payments and deductions made to these non-resident employees and corporations, all of the tax remittance that we've done on their behalf, any correspondence we had on this topic with CRA, if any, our organization charge, and all of our supporting documentation meaning the detailed general ledger, our contract with each employees and subcontractors, and all of our invoices that we receive from subcontractors or detail of the payments that we've made to employees. Please go on.
That last bullet that you see on the first page is the one that's most interesting, because that's what they base their entire decision in an audit like this. This is what it's based on. Explain in writing to Canada Revenue Agency if tax was not withheld from the amounts that were paid to these drivers, whether they're employee drivers or owner operators. Explain in detail why. Why have you not withheld tax? And there's really only one answer in these cases, which we will get to in a few moments, but essentially there has to be a formal waiver and evidence of that waiver. And there's quite a lot of work that goes into obtaining those waivers, which is why we have been so surprised to see the CRA in this case take such a firm view with regard to the trucking industry and cross-border trade between Canada and the United States.
And we'll explain to you a little bit what's going on right now with this audit initiative, but then we'll go back to this example, the case that we have just been handling recently at the office, to give you a little bit of an idea of the interaction that we had with the CRA on that and the type of arguments that we raise along the course of this audit.
So really, I mean, the threshold question here is, are there any services being rendered in Canada by non-Canadian, in this case, let's assume that they're United States truck drivers, as I say, employee drivers or independent contractors. The question is, are they taxable in Canada? The answer to that question, despite everything we've set up until this point, is generally not, pursuant to the wording of the Canada-US tax treaty. But then the next question is, would Regulation 102 and 105 still apply if they're not taxable under the Canada-US tax treaty? And pursuant to that treaty, no tax should be payable in Canada. The surprising answer there, according to the Canada Revenue Agency right now, is yes. Despite the fact that this issue is specifically addressed in the tax treaty between Canada and the United States, they still require compliance with regulations 102 and 105. And pursuant to that interpretation of the rules, Canada Revenue Agency claims to be entitled to withholding taxes on remuneration paid to a driver for that portion of a cross-border movement which takes place on Canadian soil. Never mind that the driver would be within his or her rights to claim back that tax, jumping through a few hoops to get there, but they would be entitled to that because of the tax treaty. The starting point as far as Canada Revenue Agency is concerned is you must withhold or produce evidence of a waiver from that obligation to withhold. And just, for the sake of closing the loop here, there is the text underlined at the bottom of your screen. That's an extract from the Canada-US Tax Treaty. And you can see right there in Article 15, Section 3, remuneration derived by a resident of a contracting state, i.e. Canada or the United States, in respect of an employment regularly exercised in more than one state on a ship, aircraft, motor vehicle, or train operated by a resident of that contracting state shall be taxable only in that state. So truck drivers who are resident in the United States for tax purposes are taxable only in the United States pursuant to the tax treaty.
And based on the treaty and also on a long-standing policy that seems to have been a verbal policy from the CRA, most cross-border motor carriers were under and still are under the impression that Regulation 102, 105 never was applicable to them, never needed to get a waiver, because at the end of the day, no drivers needed to pay any taxes in Canada. So for sure, they did not attract the rules of Regulation 102 and 105. So one of the first research and analysis that we performed when we were made aware of this new tax initiative from the CRA is there any administrative policy that could be enforceable? So first of all, we discussed with CRA. You may say not the best people to ask for that, but we still had the discussion with them. All of them confirmed to us that in their personal opinion, there was no policy at all in place for motor carriers doing cross-border activities, and that Regulation 102, 105 were applicable. So obviously we did perform thorough research on the topic. There is one mention of a verbal policy, which was made by David Sherman, who's one of the person who makes comment under the Income Tax Act and its regulation, who refers to a policy that will be only applicable to international shipping services. And international shipping services, is a concept that is defined in the Income Tax Act and only refers to air and ocean crew members services. So it seems that for someone who's a pilot, for example, the pilot flying over Canada back and forth will not trigger the application of Regulation 102 and without even obtaining a waiver. But it seems to be only limited to air and ocean crew members, not to truck drivers, for example. So the answers that we receive is that this policy that a lot of people were aware of seems not to exist, or at least doesn't exist anymore.
So what does that mean for a cross-border motor carrier who engages the services of a non-Canadian resident driver, either as an employee driver or an owner-operator? Well, there is exposure to potentially significant tax liabilities. First, the withholdings that ought to have been done and remitted to Canada Revenue Agency, interest, and penalties. And of course, in the context of an audit where the look back is over a period of years, if you are a larger carrier with a lot of cross-border activity, those numbers can mount fairly quickly. An assessment that we saw just a couple of weeks ago was in the range of $500,600,000, somewhere there.
Yeah.
And we are hearing from contacts and colleagues within and outside of the firm that this is becoming a more common occurrence, and the numbers are, in some cases, quite significant. So we've put up on this slide a snapshot of the penalties and how they're assessed. And of course, there you see additional penalties for failure to remit and for late filing.
Just before, if we can just go back, One point that is super interesting here is that now the amounts that is being assessed, before anything, it's a withholding amount. And as Louis and I said, at the end of the year, the drivers are not supposed to be liable for any tax here in Canada. So when one of our clients is being reassessed for this unpaid withholdings, what happened is the following. The client is liable for the withholdings with the interest and the penalty. The client pays all of that, the corporation pays all of that to Revenue Canada. So now what's the next step? Well, in a perfect world, what is supposed to happen is that all of the drivers for which we have remitted withholdings to the CRA should be contacting the tax authorities, filing a tax return, which will be in this case a nil tax return, and asking for a refund. And what possibility will be that once all of the drivers obtain their refunds, they can pay back the motor carrier who paid the withholdings on their behalf. But as you can see from Louis' reaction, even if it's not a real tax that is normally refundable, the clients, they don't want to go through this process. First of all, it's a very heavy process on the shoulder of the corporation, and to ask all of the drivers to refund them is a lot of pain also. So a lot of people right now are paying the withholdings, the interest and the penalties, but think about it for a second, for amounts of taxes that should have never been payable to the CRA from the very beginning of this.
So in effect, it is a windfall for Canada.
Yeah.
Thanks to the CRA on taxes that should not have been payable in the first instance. And in the context of an audit, the likelihood of drivers after the fact filing those tax returns to claim back refunds is probably next to nil. Keeping in mind the nature of the business, the amount of turnover, the dire shortage of drivers from time to time, it's unlikely that any motor carrier is going to pursue recovery of those monies from their drivers after the fact, particularly if it's an audit that's occurring a few years after the shipment in question affecting a specific driver. So are there any options to avoid the application of regulations 102 and 105? There are. None of them are perfect, but we're going to go through them with you now. Option number one, this would apply only in the case of employee drivers, and that would have the motor carrier require each of their non-Canadian employee drivers to register with Canada Revenue Agency, get an individual tax number, because presumably they cannot get a social insurance number, and file an application for an R102 waiver. Every single one of those cross-border employee drivers. It's not a practical solution. None of those drivers are going to be in a hurry to provide Canada Revenue Agency, a foreign tax authority, with all of their personal information. But nonetheless, this is how the option is structured. Should we talk a little bit about how they would become qualified for waivers under 102?
Yeah, well, the qualification is not so difficult to obtain. It's either if you have a remuneration that does not exceed $10,000 in a calendar year, which does not apply to most of the drivers. So the one criteria that is the most interesting one is that the non-resident, so the driver is present in Canada for a period that is not exceeding a total of 183 days in a particular calendar year, which normally applies to most of the drivers. Now, there are sometimes some question about, well, what does it mean spending a total amount of 183 days if I'm a driver and I spend half of my day in the US and then I cross the borders in Canada in the afternoon and then I'm back at night in the US, have I spent an entire day? Normally, the tax authority will consider that every time you put 1 foot into Canada, you've spent a day in Canada. So you have to be a little bit more cautious in the way you do your calculation. And very good once you've obtained the waiver, but annually, the drivers needs to go back to the CRA and request the same waiver. What's interesting also is even if you get the waiver and you don't have to withhold, there's an obligation on the shoulders of the employee. He still needs to file a nil return with the CRA on a yearly basis. It's not difficult to file that, but it's an extra burden on the shoulder of your drivers.
So when we said it was hardly a perfect solution, we meant it. It's not a perfect solution. It's onerous, but it is out there. It's one option. Owner-operators, on the other hand, do not have any option. They have to obtain a Regulation 105 waiver. They're generally available to them, assuming that the owner-operator, the company, the subcontractor, does not have a fixed base or a permanent establishment in Canada. They got to be able to establish that their residency, their domiciled in the United States or some other country with which Canada has a tax treaty that deals with this particular issue. And they need to be able to demonstrate to Canada Revenue Agency that they're entitled to treaty benefits. Very important, the application under Reg 105 has got to be filed at least 30 days prior to the commencement of services or first payment for those services. And it's possible, when you read through the guidelines published by Canada Revenue Agency with regard to a Regulation 105 waiver, it is possible that the CRA will ask an owner-operator to provide security in an estimated amount roughly equal to the potential Canadian tax liability.
So that was option number one. It's for us the most common option, but not an easy one to apply. Option number two is not a real option. It's only a partial option, is for the corporation to get a qualification as being a non-resident employer. So our Transportation Service Corporation can go directly to the CRA, filing a form, it's Form RC 473, seeking to get the designation as being a qualified non-resident employer. And if the designation is allowed, the carrier will then be exempt from doing any withholdings on the payment paid to their employees, meaning that this designation only applies for the employees. All of the subcontractors are not targeted by this qualification. And when you get the qualification, the company, this qualification is only valid for a 2 years period. So every 2 years, you need to reapply for it. And then there's so many rules that applies to this. So as I said, only applies to employees. Now, the designation only provides an exception for the federal withholdings, the federal income tax withholdings. It does not address all of the other withholdings requirements, such as the Canada Pension Plan, for example, does not apply also to provincial withholding, if any, there are in Quebec, for example.
Quebec has its own exemption application.
Exactly.
Provincial portion of the tax.
But also only for the provincial income tax. So all of the other withholdings are not covered by the exception.
So you can imagine Canada Pension Plan here, Quebec Pension Plan, employment insurance. These are all source deductions that would normally apply in the context of employment in Canada. Those are not going to be protected by way of an exemption from being a qualified non-resident employer. There may be other exceptions that apply. We've given a couple of examples there. So again, not a perfect solution and only a partial solution, because that qualified non-resident employer designation will only address the concern with regard to employee drivers.
And when you obtain the qualification, it means that normally for your employees, you don't need to obtain waivers from them, but it only applies if the employee works less than 45 days in a calendar year that includes the time of the payment in Canada, and or is present in Canada for less than 90 days in the 12-month period that includes the time of the payment. which means that we're not just looking at the calendar year, we're looking at a time frame that is always evolving. And the burden remains on the taxpayer. So in this case, on the transportation corporation, to track down every employee's regarding the time that they've worked and that they've spent in Canada, and to make sure that they always follow up with the requirement of the 40 days period and the 90 days. And you know, for the 102 waiver with the 182 days period, most of the drivers qualify for that. But working less than 45 days in Canada in a calendar year is not a lot. So there are a lot of drivers who, even if the employer has the qualification, they're not entitled, and they need to get the normal and general waiver because they're spending too much time in Canada every year working.
So when you think about it, this obviously will have implications for how you word your agreements with employee drivers. You're going to have to require non-resident employee drivers to disclose every single day or part day that they're working in Canada. Now, you may be able to track that directly yourself if they're assuming that they're only working for your company. But then they also need to disclose to you every day or part day that they're present in Canada for reasons unrelated to their work. They've come up for a family occasion, a birth, a wedding, a vacation. They need to tell you that. They also need to keep you apprised of any changes in their domicile or country of residence for tax purposes. And I would suggest that those employment agreements now would also need to require the driver to acknowledge that they may still be subject to Canadian withholding tax on the amounts that are paid to them for that portion of the services that are being rendered on Canadian soil if there's a change in their domicile, or if they hit one of those thresholds, 45 days of work or more in any calendar year, or 90 days or more in any 12-month period in Canada for any reason.
By the way, when we discussed with the CRA in the audit that we just finished recently, one of the first elements we raised to them was, well, I mean, it's a terrible outcome for the taxpayer. How do you want the taxpayer to be compliant in the future with these requirements? And the golden answer of the CRA was, well, they just have to ask for disqualification. It will solve all of their problems. So we started discussing a little bit more with the auditor, and we had a lot of people involved at the CRA in the file. And we said, no, look, we have subcontractors who are not targeted by that. We're sure we have drivers who spend more than 90 days in Canada per year, or they work more than 45 days in Canada per year. They won't be targeted by the qualification. So it's going to be even more difficult to work with both the qualification and sometimes with the waiver or to withhold in certain case. And the answer was, well, we don't care. You should be compliant with the law. That's what the law says. This is it. That's basically the answer that we've received, which is a struggle for companies, because the problem is not that the company do not want to be compliant with what the law says here in Canada. The problem is, how do you comply when the struggle is so big, right?
The burden is exceptionally high. But as you can see, I mean, if all else fails, just withhold. Now, motor carriers are going to have to decide whether they are withholding from drivers who are in that pool of cross-border drivers, or if they're just going to gross up and make that payment themselves and leave it at that. So it's an additional burden on the company that frankly should not apply.
Right. But by the way, withholding being the third option, with the audit that we just finalized, we've received our assessment for the withholdings, the interest and the penalties. We have also recently received T4s from Revenue Canada who submitted T4s for all of our driver employees, and they will do a similar return for the subcontractors. And we need to send to all of them their tax information from Canada, and they will have the possibility to get a refund. But that's basically, if you withheld, that's what you're gonna, if you withhold, sorry, that's what you're gonna be doing in the future. Each year you'll have to send them all of the tax documents that are related to the withholdings in order for the employees or the subcontractors to be able to gain back these payments.
And just for clarification, the T4 is the tax slip, the tax information slip, which sets out for the benefit of the employee and their tax advisors how much tax has been withheld and remitted to Canada Revenue Agency.
Exactly. Now, before we finish, and if you have any question, like one of the elements that we look into was, well, how do we withhold? Meaning, if I'm paying a driver for, first of all, when I pay my driver, I pay him for mostly more than one loads. But let's say I'm paying him just for one transport. Well, my transport may very well start in Chicago and end up in Quebec City, for example. So am I rendering services in Canada? The answer is partially yes, meaning I have a portion of my truck service that is rendered in the US and one in Canada. So how do you deal with that? And that was one of the issues in our audit, because we were making payments to our drivers, not looking at the differentiation between the services rendered in US or in Canada in this example. So one of the negotiations we've made with CRA that worked, if you are stuck in this position, is that we took a sample of invoices that were issued by our subcontractors and payments that we've made to our drivers. We look at the loads, at the transportation services that were rendered. We calculated the kilometers that were performed and driven both in the US and in Canada. And we've pro rata basically the services between the US and Canada. And we've determined that the withholdings should be a certain amount if we look only at the services rendered in Canada. That's something that is extremely important, because the tax authorities, if they want to be very aggressive, they have the right to withhold amounts on the entire value of the payments you make to your drivers, if there is no differentiation between the services rendered in the US and in Canada. So if you're able to at least explain what portion was made to the US and to Canada, you'll have an argument to try to reduce the value of the withholdings that they're requesting from you.
So in a nutshell, the burden is quite significant. Interestingly, in the budget that was tabled 1 month ago,
Yep.
2 months ago,
1 month.
this issue is actually addressed, and it talks about the withholding obligations with regard to non-resident service providers, and it acknowledges that existing income tax rules require a person who pays, a non-resident for services provided in Canada, to withhold 15% and then remit it to Canada Revenue Agency, and that this is effectively a prepayment of Canadian tax. But in many of those cases, those non-residents actually don't owe the tax, and this is acknowledged in the budget document, because of provisions in a tax treaty, such as the Canada-US tax treaty that we referred to earlier. This, our tax authorities are fully aware of this, and finance clearly acknowledges that because of this requirement to withhold and the ability to apply for refunds and the burden that all of this poses, most non-resident service providers will instead pass that cost on to the payers, which ultimately increases the cost to Canadians. So in the budget for 2024, there are proposed changes to the tax rules. Interestingly, though, they only apply to services that are rendered in international shipping or from the operation of an aircraft in international traffic. So we're back to those two exemptions that we referenced earlier. There's no mention in here about a similar concession or a similar correction within tax administrative policy with regard to cross-border truck drivers, unfortunately. So that's what we thought we'd highlight for you today. We believe this is an important issue, and just through our discussion with Canada Revenue Agency and with clients, we are starting to see and hear much more of these instances, these audits targeted directly at non-Canadian, primarily US trucking companies that engage the services of non-Canadian employee drivers or owner-operators. It's something which we know both the Canadian Trucking Alliance and the American Trucking Associations are fully aware of. So this is not something to be disregarded. And frankly, when you look at the penalties that could result from non-compliance in the event of an audit, I think every cross-border carrier that engages the services of non-resident drivers would be well advised to come up with some strategy for gathering the information that they need and tackling this issue going forward.
Yeah, totally agree with you. By the way, if you are facing this type of situation and don't know what to do, obviously we're always available to discuss with you, and be aware that there are some possibilities to go and discuss with the CRA even before an audit to become compliant, such as doing a voluntary disclosure to avoid penalties. So there are things that can be put in place as a protection even for what has been done in the past. So if you are interested in anything, we're always there to discuss with you.
Thanks very much, Mary Ellen.
Thank you.